that bank shall identify in CP and stress. You shall create a SMA 0. I take your lordship to the notification. The scheme is the when
you have taken me through the entire notification last time.
Then I am not troubling your lordship.
Yes.
To repeat, my lord, the scheme is, it is not that something is written off. The whole effort is to, sir, give one opportunity to make the one opportunity, one effort, that MSMEs don't die. It doesn't perish. And that is in the national interest, in the interest of the economy, because MSMEs contribute to 60% of employment, 45% of the exports, and 30% of the GDP. It depends, very depends. If 10 years before, what is maybe slightly more. Now it is maybe slightly, some differences are there, but approximately this is the position. So therefore, my lord, then the very task of the resolution of stress was given to the bank itself. May take your lordship to page 71, the composition of the committee. I will not read it.
You have taken
yes.
I've gone
so
to that.
Therefore, my lord, now, then it contemplates three, without repeating, it contemplates three scenarios. SMA 0 when I identify it. When the rest of the world doesn't know, there are no signals. Then SMA 1 when there is a default. SMA then, once there is a SMA 0 when there is no default but bank identifies. SMA 1 when there is a default. When there is a default, there is no other option. The committee has to be constituted. An application has to be made to the committee. The committee will make an attempt for resolution of stress. It will issue notice to all concerned and keep a moratorium till there is some one way or other it is decided. And the committee is empowered to permit recovery. Only 1 second I read from paragraph 73, recovery. Only one page. Page 73. Yes. Yes, recovery. Once the first two options at A, rectification involves further investment by the bank. B, restructuring. Above are seen not feasible. New recovery process may be resorted to. The committee may decide the best recovery process to be followed among the various legal and other recovery options available, with a view to optimizing the efforts and results. And then at page 78, review at page 78. Paragraph 15. In case the committee decides that recovery action is to be initiated against an enterprise, such enterprise may request for a review of the decision of the committee by the committee within a period of 30 working days, etc., etc. The request for review shall be on the following grounds: error or mistake or error apparent on the face of record, discovery or review, etc. The CPC only. So, my lord, therefore, it's a judicial tribunal, and its decisions are final, binding, and authoritative. This is a substitution of the EFR. And if any person agreed by non-constitutional committee or anything of the, then the forum is civil court or 226. Because the MSME Act, which creates certain rights and obligations in terms between the borrower and the banker, insofar as it has not created a tribunal or a forum for enforcement of the same, the jurisdiction of the civil court is not out. This is the crux of my argument. And this notification has not been given effect to by not a single bank or financial institution in this country. That is undenied. And now I take your lordships to the judgment of the Madras High Court, Madurai bench. The Madurai bench repeatedly asked them whether any committee has been ever constituted. This is the Canara Bank, I believe, Canara Bank. No bank, State Bank of India, no bank. Nobody has ever created Canara Bank. At page 305, paragraph 11. Yes, paragraph 11. In fact, when a specific question was raised by the bench, whether the Canara Bank has formed any committee which is mandated under clause 2 or the framework, etc., it was submitted that no such committee was formed. Then again in paragraph 12, further in the above clause 2, subclause 2, it is specifically stated that distressed micro, small and medium enterprises shall have access to committee. When no such committee was formed, then the distressed MSMEs like the petitioners were deprived of any such opportunity to approach the committee. The bank is contending the petitioner has to raise the issue of the benefit under the MSME scheme at the earliest point of time. When there is no committee, then such plea of the bank cannot be entertained. Then the bank goes on to say, next page, my lord, at page 307. Yes, then it comes to this party has come to many times, asking as in Mohan's case. Then the court says there is no discussion about 2015 notification at all. Therefore, the plea of res judicata is rejected. The bank said the party had come a number of times earlier and afforded granted some installment facility, some protection, etc. Then, my lord, the court is again discussing it the same in paragraph 310. That is page 310, middle part. Page 310. In the present case, almost at the middle, your lordship got me now?
Yes.
In the present case, the issue of statutory duty was not decided in the High Court, and the petitioners are agitating exactly on the statutory duty cast on the bank. Hence, the argument of the bank cannot be accepted. The bank has said, the contention of the bank that they had come many times before the court, they did not raise the issue, and therefore there is a res judicata. Now, then I read one or two sentences from this judgment at page 314, paragraph 20. The banks are the backbone of India's economy, and it is the duty of the banks not to get the business unit. Then last sentence of the same, the courts with the heavy heart is recording the fact that banks cannot act like a Shylock fond of flesh. And coming at the last paragraph 23, yes, etc., the respondent bank is directed to formulate the revival and rehabilitation scheme to the petitioners unit under the notification of 2015 and as revised from time to time, and the same shall be carried out as per the notification of 2015. This is what, my lord, I read the bare minimum, and my lord, similar is the judgment of this court at the hands of Justice Diaz and PDMC's case. This judgment starts at page 258. I will not trouble your lordship much on this issue. Coming to the last paragraph or last page at page 283 at paragraph 31. The objection raised by the respondent bank that the repetition is barred by res judicata due to filing of the earlier repetitions. I wanted to help my friend Mohan. Yes, earlier repetitions, numbers, etc., and the subsequent proceedings in review petition, etc., cannot be sustained. In repetition number, etc., in the last series of petitions, the court has especially left all contentions of the petitioners open. Given the above, none of the judgments cited by the respondents apply to the facts of the case. Now, the doctor res judicata, I brought a book, my lord. Last time, my lord, I brought the authoritative books of, Everest on estoppel, Bigelow on estoppel, Kasparas on estoppel. But, my lord, this time I brought a small book. Yes, my lord, I take your lordship to one paragraph, one sentence. Yes. Now, my lord, now, all of the doctor res judicata comes from Rome. Yes. You have the same thing? Yes. That photocopy you have? Yes. Yes. Yes, 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 yes. I just want to, yeah. Yeah. These are two different editions, so there's slight difference is there. The same book, you know, Spencer, Bauer, and Hanley, the same book. This is the earlier, this is the earlier edition. There's a slight difference in that case. Now I'll pass on this. Yes. Yeah, just pass on. You have an extra copy. I will be early, right? Yes. Yes. Now, my lord, yes. At page 465. Not page 465. Page 273, paragraph 465. Arnoldus Vinnius, the Dutch commentator, Marshall called it. His annotated edition of Justinian's Institutes gathers up various constituents of Roman exceptiori judicate in one comprehensive formula as exceptiori judicate non aditer petendi obstat quam si idem questio inter idem revocator indica et damnam nasset si omnia sunt idem corpus, idem quantitas, idem just, idem cosa petendi, idem conditio personarum. So, my lord, the 6 conditions. The doctor Residicata, I'm not able to by heart the entire thing. It will apply provided, my lord, si omnia sunt idem corpus, idem quantitas, idem cosa petendi, idem just, idem cosa petendi, idem conditio personarum. And in put in simple words, my lord, there should be complete end of the litigation. Litigation should have come to an end. None of these proceedings, there is no end to the litigation. Surprising proceedings have not come to an end. Until and unless there is an end to the whole litigation, no doctrinal certificate applied, doesn't apply. Now, for instance, my lord, these petitions are only on a narrow realm. I claim my duties or my proceedings are founded on 3 premises. One is there is a statutory prohibition. I come to the High Court only for enforcement of my rights in the relevant public law. There is a statutory prohibition restraining and prohibiting from the banks from invoking surprise. And they are duty bound to make an effort for resolution of stress. Then they can recover. And this is one cause of action. Where I come here. I may be able to go to a civil suit, that's a different issue. But your lordships can say, you have at your lordship's discretion, at least entertain a petition where a public law remedy is sought. And otherwise, my lord, 226 High Courts, we don't need it. We are now going to yesterday High Court of the 3,500 crores. If if the civil court system is revived, the civil courts are given are treated as a true constitutional court, there is not, you don't have a need to have a big High Court. The foundation has to be broader and strong. That's my opinion, yes. Therefore, the High Courts exercise jurisdiction as the King's Court in England used to exercise for enforcement of public law remedies. Now, I have other remedies, breach of contract. There are a lot of issues which I have not raised this. There are malicious action, notice action. Those issues I have filed a suit in the Bombay High Court. And the suit is pending. And now, all of these cases, the question of residicata does not apply. Now, this is what the Malad Justice Mohammed has said, and these 2 petitions were allowed. Now I take your lordship just to give the entire background of this case. Why I say that, Malad, why I am mentioning all this is because I made the Attorney General a party. And I know when Attorney General a party, I expect the registry even to raise an objection. And therefore, Malad, Attorney General used to be made a party in all proceedings in the Supreme Court in his earlier days. This 11th constitutional bench of the Supreme Court in Katikal, Alagar. That's it. I just the printout has not been done. Katikal Alagar was the full court judgment of the Supreme Court. The issue was the protection under Article 23, Article 20 sub Article 3, that is no person accused of an offence shall not be compelled to be a witness against himself. That is, accusare nemos et debet nisi coram deo. No, nobody is to accuse himself except before God. Protection from self-incrimination. That protection is available whether it is at the stage of registration of FIR or even prior to that, when you are in the status of a accused, or that the protection is available only at the trial. That was the issue that was before the Supreme Court. Now the Supreme Court said, now the protection is available not merely at the stage of trial, that protection is available right from the beginning stage of when I am in a position, I am in the status of an accused. Yes, I am in the status of an accused. Now, therefore, I am referring to Kathikalu Allakad only for the purpose to say that Attorney General, where a substantial question of law as to the interpretation of the Constitution and statutory instrument is involved, the Attorney General is a necessary party. I am sorry, my Lord, I am the hard copy. Shall I have it? Just have it. No, my Lord, the AR 1961 online SC Supreme Court 74.
AR
AR 1961 Supreme Court 1808. 808. AR 1961 Supreme Court 1808. The entire Supreme Court then had only 11 judges, led by Justice B.P. Sinha CJ, S.J. Imam, S.K. Das, B.P. Kajendra Gadkar, A.K. Sarkar, K. Subrao, K. Baju, K. Das Gupta, Ribis, Dayal, Tatagwan, Ayimkar, and Madalolkar. So I read it because I have great respect for all these great judges. So, Manati, Kathikalu, yes. State of Bombay versus Kathikalu Ogad. Attorney General, they responded. So, then order, CPC, order 27A of the CPC. Under the CPC, the amendment was introduced in 1972. And where an interpretation as to the Government of India Act is involved, or any statutory instrument is involved, where it is concerning the central legislation, the Attorney General has to be head. And when it is concerning the legislation of a province,
He can represent the Union of India.
no, the other case, Advocate General. If it is a state legislation, the state enactment, it is the Advocate General.
Why do you want to make the Advocate General or the Attorney General party is representing the Union of India?
No, Attorney General, no, the order, this is the CPC, right? Oh, yeah, yes, yes. Order 27, yeah, yes, 27, order 27A, or the CPC. Order 27A, yes. Yes, 27A. 27A, yes. Suits involving substantial question of law as to the interpretation of the Constitution. Right to that minute was the Government of India Act. Yes, suits involving, heading, yeah. Suits involving a substantial question of law as to the interpretation of the Constitution or as to the validity of any statutory instrument. Notice the Attorney General or Advocate General in any suit in which it appears to the court that any such question as is referred to in clause 1 of Article 132 read with Article 147 of the Constitution is involved. The court shall not proceed to determine that question until after notice has been given to Attorney General of India if the question of law concerns the central government and to the Advocate General of the state if the question of law concerns the state government. And there are cases where the state is nowhere involved, like disciplinary proceedings against lawyer, interpretation of the Advocates Act, not of India. I'm talking about the English judgment. There, the Attorney General filed the appeal because Attorney General, Attorney General is the sole custodian of the public interest. Now in the PA, Attorney General is made to sit outside. The PA petition is the Attorney General. So Attorney General is the sole repository of the public interest. And any decision, any question of law, a decision involving any question of law certainly involves public interest. And that is the reason why, my lord, Attorney General is made a party, and my primary request is
You need to give only notice to them.
No.
അതിന് പാർട്ടി ആക്കണം. Because you are giving notice to the Advocate General or the Attorney General when the state or the union is a party.
I agree with you, Lord. I did so. Ex abundantes cotilla, non nocet, abundance of caution does no harm. So therefore, there is a specific. Otherwise, my lord, now, my lord, one other point, one word about the facts. See, many people have the impression when I take up, because not that I am quantifying myself or nothing of the sort. I am a very ordinary person. Neither that good or neither that bad. So I take up the briefs which comes to me. But I certainly have some concern about the public interest. Not every brief I don't take. I must have some. I must be personally satisfied that okay, it's worth taking the course. But the common perception is the debtor is asking for no payment at all to the bank. The borrower need not pay to the bank. That is not the case. And my lord is decided in favor makes no difference. All that is my job is to point out, bring to the notice of the court what I wanted to say, and the judge has understood it, and he is rejecting with good reasons. Then I retrospect where I went wrong. So I don't want any kind of. It's all humility only. I shall always say I don't want any favor. That I don't want. I am not a beggar. That is not any kind of an arrogance. It is only a humility that I say I don't want it from anybody, from any favor from anybody in my life. That is all. Nothing else. I should not be misunderstanding. So I take your lordship to. Maybe our efforts are back something now. Yeah. So, my lord, therefore, yes. Therefore, your lordship has paid 333. Grand total, National Company Law Tribunal, grand total, 49,000 crores. I guess it's difficult for me to read even. 49,000 crores. That's why I'm not reading. I'm unable to read it. That is the claim. That is the amount due from Anil Ambani. And it was settled for 92 paise per 100. We kept on arraying Anil Ambani, we are raising the issue. Whatever social media, wherever it is possible, we wrote to the government. Look here, it is plunder. I don't think it is because of our effort that now the ED has registered cases. We don't know. If it is so, then we are happy that it has happened. Then, my lord, yes, I take your lordship to another order. At page.
No, this is coming for the first time. What is the immediate threat against you?
No, my lord, I
take your file a counter to it.
Yes, my lord. I am protected by the Bombay High Court till today. I take your lordship to page 400. And before I take your lordship, only 1 second, I take your lordship to page 378. Only 1 second, fraction of a second.
378.
378. Yes, 378, my lord. Your lordship got 378. This is last time, the other 49,000 crore was for 92 paise per 100 rupees. Here is 35 paise for 100 rupees. This is looting. The other case, Mukesh Ambani made the resolution of resolution applicant. Many things, if I had a public forum, I could have said many things. I restrained myself. So therefore, here, the public money is looted. and it doesn't happen. This is, there are many things I can't say, but I don't want to say in a court. So this is how those who speak of public money has done. 53 banks, the, the banks and financial institution which has not considered not a single committee to extend this benefit to the MSMEs has been party to this plunder, and there are many other cases I can point out. Anything above 5,000 crores loan from a bank, it is 10%. Anything above 5,000 crores. Chanda Kocha, yes, many things I don't want to say. 10%, 10%. That's all. Loans are given without any security. How come the settlement for 35 paise for 100 rupees happens? Because money was lent without any security at all. Where a micro unit seeks some small money, small loan, the RBI guidelines says that they don't have.
Are you going to take risky position with secured assets? Have they produced a notice here?
Yeah, produce High Court order.
No, not the notice issued by the commissioner. Take risky.
Yeah, I take your lordship this notice. The page which was 255 around. And the commissioner's notice is a human error. I'm not making much noise out of it. There's an error. And I told the advocate commissioner, you correct it. So where is human error? Page 256.
15th October.
15th October.
That was sought to be taken yesterday.
No, my lord, the
interdicted by the Bombay High Court. Granted till today it is.
Yes. And the date was given on 6th. That's an error. I don't make him. Only I said, you can issue a press notice.
It was 6/11.
No, they intended was 6/11.
It was wrongly noted as 6th.
6th. My lord, there's a principle.
Yes.
Falsa demonstration non asset. Falsa grammatica non corrupit testum. But falsa demonstration, suppose Rama is a Ramu, then but date is different. Date is something doesn't come under the protection of falsa demonstration non asset.
Yes. What do you say? Non-MSME. Yes. For non-MSME accounts, rate of interest is for non-MSME. This is action letter. When was this? When was the NP? When was? So this is the last one. Last one.
Okay.
need not read it. When was the account classified as NPA? Right?
Exhibit
31/1/2025. Okay. Belong to MSME. If they belong to MSME, have they filed any objection to 13(2)? You must have seen ground number, the relief number 2 for that. No, relief number 2. You will get the answer in relief number 2.
That my friend says is if there is some fraud, etc. One second. If there is some fraud, etc., then he is disqualified. I will not stand for him.
I should give him an opportunity
Yeah,
to
so
file a
let him
counter.
file a counter.
Yes.
Yeah, my lord, if my lord, all these schemes, if there is a fraud, I'm not entitled. That is what the notification says. So if there has to be something on record, then it's a matter if your lordship decide. It is not me who has to say. If there is the material shows that there is.
Have you replied to 13(2)?
No, 13(2) we have not replied.
Not replied.
No, not replied. No, not now. Whether 13(2).
Which is the first instance where you have brought to the notice of the bank that you are an MSME?
No, my lord, my contention is this is my contentions are in all cases is that there is no
You are not required to.
required.
It is for the bank to come and see whether
Yes.
you are an MSME or not.
No. Because the notification, I think that this is the just possible. Yeah, can you please? The entire thing is not something today. It has been ever since. Ever since I take your lordship to the page number 2002. I'm speaking generally about the case, not about this particular case. Yes. Page 1. Yeah, 16 January 2002. Guidelines for rehabilitation of 6 small-scale industrial units. Now, then went on at page, without taking time, at page 8. At page 8. Illustrative warning signals of incipient sickness that are drawn up during the scrutiny of the borrower accounts and the related accounts, etc., etc. So these are all the illustrative signs, and the notification dated, the 2016, 17/6/2016, which is in furtherance of the.
No, your contention is you need not go to the bank and tell that you are an MSME.
No, they have to identify.
They have to identify.
Yes. May I take your lordship to page 114. I read the bare minimum. In order to provide, your lordship,
Yes.
in order to provide a simpler and faster mechanism to address the stress in the accounts of MSMEs and to facilitate the promotion and development of MSMEs. The Ministry of etc. by the Gazette etc. dated 29/5/2015 had notified the framework etc. However, certain changes in the caption framework has been carried out in consultation with the Government of India, Ministry of MSME etc. And then, accordingly, a revised framework along with the operating instructions is furnished in annexure, and that annexure is at page 116. And your lordship will find.
This is the same. 15 continuation ആണല്ലോ ഇത്. ആ ബുക്കിലുള്ള തന്നെ continuation ഉള്ളത്.
അല്ലല്ല.
അത് 2015 was the original one.
No. This only contains the this doesn't contain any RBI notification.
Okay.
This is RBI notification. This entire paper book is of RBI notifications on exercise. And I take your lordship to page 126. Illustrative signs of stress of categorizing an account as SMA 0 and simple para 3, return of 3 or more checks. So the banks have to identify it. And now the electronic era, everything red signal comes, red flag, they call red flag. So bank has to initiate that, identify it, and they have to create a SMA 0 even when none of these stress signs are seen, even when the account is not irregular. So the entire burden is on them. And then, the notification itself, I believe that if it is a willful defaulter or any fraud, etc., the benefit is not available. If my friend has a case that my client, he has to file a
counter to that then.
My lord, so far I understand. I can only plead for my client.
What is secured asset? Is there any building there? Residential building or?
Subject to what my friend says, what I understand is, my lord, what he has told me is that he is the goods is mostly in spices, kurumala, so they got damaged because he was running the business for the last 30 years. The trouble came only in 2024, and thereafter maybe to keep the account in non-NPA etc. They must have done something. I have no idea. So therefore, that is the scenario. It's not somebody. It's a business which his father started.
Can you file a counter? 3 days time. You are taking notice for respondents. You meet their contention that there is no I file a file your counter within 3 days. You are representing the Bank of Maharashtra. Respondents 1 to 3 so and so take notice. GP, fourth respondent. Reserve Bank, any standing notes of Reserve Bank you have served?
I take notice by speed post, madam.
There is a standing notes.
I used to be standing notes. I gave up all in 2000 to 2000.
Notice to respondent number 5 is speed post. GP 6, 7 and 11. What about 8? 8 in avashyillalo. 8, 9, 10, 12. 14, 16 dispensed with for the time being. 13, 14 dispensed with. The respondent 1 to 3 is placed for time filing a counter affidavit and submits that the petition itself is not maintainable and cannot be entertained because of the fact that in Exhibit P13, renewal of existing cash credit facility to tune of 30 crores in column number, in the column where rate of interest is stated, it is specifically stated that the interest rate is the applicable rate of
that
interest.
That cannot be raised because what is required, if I am an MSME, I am indebted, irrespective of the nature of the loan.
I am reiterating this contention. The applicable rate of interest for non-MSME account is applicable to the petitioner's form. The present apprehension of the petitioner is that the commissioner has already issued Exhibit P13 notice. P13 alla.
P70. 250, P70.
P17 on 15 October 2025 that he will take physical possession of the property on 6/10/2025. In fact, it should be read as 6/11/2025, and at the point and the petitioner has approached the High Court of Bombay by filing WPC number 35163 of 2025, and the said court by judgment dated 6th November 2025, and the counsel appearing for the petitioner sought leave to withdraw the petition to move this court, and taking of possession was deferred till today. Since possession is to be taken today, or tomorrow, the petitioner, the counsel for the bank submits that this court may not interdict in taking physical possession as the petition itself is not maintainable. Since it is further submitted that the petitioner has not availed the statutory remedy available to him and has approached this court under Article 226 of the Constitution of India, and by going by the decision of the apex court of so and so.
No, myself, that is where the MSME Act in front of us, it creates certain rights and obligations in addition to what is recognized by common law. The civil court jurisdiction is not outside, and that is what Karnataka Madras High Court has also.
Statutory remedy this remedy is not maintainable. The question as to whether the petitioner is entitled for the revival and restructuring based on notification.
Notification dated 29/5/2015.
Is a question to be decided after after the counter affidavit is being filed. In such circumstances, deem it appropriate to pass an interim order deferring the taking of physical possession for a week, post on Thursday for counter affidavit of the respondent.
Yes. Wait. Stay.
You can take this, that audit report. Yes. Anybody appearing with BSNL? Have you given copy? It's only a form. 34 notice അല്ലേ ഉള്ളൂ അല്ലേ? ഡിമാൻഡ് നോട്ടീസ് അല്ലേ വന്നിട്ടുള്ളൂ? That respondent? Ah. Ah. What is the amount? അത്രേ ഉള്ളൂ. 71,000 ഉള്ളൂ. ഇത് എന്തിന്റെ റിക്കവറിയാ? Broadband connection? If you want a stay of the revenue, you have to deposit some amount.
They have only given proceedings and arbitration. That's an issue. We have also filed a representation towards the first student for referring the matter for arbitration.
If you don't want to stay, then no. Notice എടുക്കാൻ പറഞ്ഞുള്ളൂ. Get instructions. Stay ആണെങ്കിൽ conditions stay പറ്റുള്ളൂ. Nothing is going to happen. 34 notice മാത്രമേ ഉള്ളൂ. Before on condition. Then revenue recovery matters, money matters, you have to be conditional account. Settle how? അപ്പോൾ പൈസ കുറച്ച് അടയ്ക്കുന്നത് ഒന്നും കൊടുക്കാനില്ല എന്നൊരു കേസ് ഉണ്ടോ? അത്രയല്ലേ ഉള്ളൂ. then pay 15,000. 15. RR stayed on condition the petitioner remits 15,000 within 2 weeks. $300. Any? $301.
It's a matter of 2019 matter. We have
No, the interim order was passed. No, interim order was agitile. Directing deposit of 55 lakhs on or before 10/12/2019, which was not complied. Therefore, the writ petition stands dismissed. Next. No, dismissed as not pressed. Infractions. The petitioner mediation failed.
Mediation failure, Lordship. 2020 matter, Lordship.
Then what?